Good morning. The atrocities being committed by political parties who are ruling the government was out of our public fund tax being paid, which is being accumulated in exchequer, is paid and distributed to the advocates who are appearing for the state governments. But the present government has introduced a new scheme permitting raw advocates who do not have any experience, who are not concentrating on any subject, are permitted to argue and earn money. Huge number of entire population of ruling party and advocates being were deployed in representing the state government. Forget about that. A similar situation. Apart from that, yes, different situations had occurred in Madhya Pradesh, wherein Advocate General refused to prepare an appeal against the order, and some officials, by engaging private lawyer, prepared writ appeal. So that was challenged before Madhya Pradesh High Court Division Bench. This is AR 2025 Madhya Pradesh 151. AR 2025 Madhya Pradesh 151. State of Madhya Pradesh versus Kailash Hans. They say filing of writ appeal, representation of state by private counsel, filing of writ appeal by state government through private counsel without approval of law department or office of the Advocate General is impermissible. No suit or appeal or petition can be instituted on behalf of the state or against it without proper authorization by law department and through Advocate General or designated government law officer. They have referred Article 165, 167 of Constitution of India, as well Madhya Pradesh State Litigation Management Policy. So I would like to share this litigation management policy, which was referred in this judgment, which will enable you how the law officers and the authorities should work together and assist the courts in rendering the administration of justice. So they say there are in the Madhya Pradesh there are three wings, namely Part A legal advising wing, Part B litigation wing, and Part C legislative wing. Class 2 and Part A deals with authorization of officers to execute contracts, so and so, so and so. All these things have been discussed, that you go through that. Then Article 165 authorizing to appoint an advocate commissioner, advocate general. This is most important. Functions and duties of the officer in charge of the case. This is in administrative guidelines of the Madhya Pradesh. UBC conduct of the officer in charge of the case should conform to the following norms. After receiving a letter of appointment, the officer in charge shall study the case file, prepare a brief note of facts before contacting Office of Advocate General, collect all necessary information, documents, data, circulars, notification pertaining to matter involved. The officer in charge shall also make necessary communication and coordination with the legal cell of the department so as to ensure that he is well equipped with the relevant information and documents pertaining to the case. The officer in charge, before arriving at the office of the Advocate General, shall first contact nodal officer of the department, share the detail of the case and obtain the current status of the case before getting the file marked from the office of Advocate General. The officer in charge shall contact the law officer to whom the file is marked on the same day and shall follow the instruction given by the law officer in respect of the case in hand. In case he could not get the return appeal consent proceeding prepared or filed, he shall get an endorsement about the next date for concerned law officer with specific reason. The officer in charge shall not keep the file of the office of Advocate General unnecessarily in his custody after leaving the office. The officer in charge shall be responsible for making immediate communication to the concerned departmental authority through legal cell about any instruction given by the Office of the Advocate General. The officer in charge shall be given direct access to the head of the legal cell so as to ensure that no unnecessary delay is caused in transmitting information document to the Office of the Advocate General to facilitate speedy disposal of the case. The officer in charge shall be responsible to handle each case assigned to him till the litigation is completely set at rest. He shall constantly monitor the court proceedings in relation to the cases assigned to him and send the monthly status report in this regard to the legal cell of concerned department. It shall be the personal responsibility of the officer in charge to ensure that the cases are properly defended in the courts of law. The officer in charge will be appointed by mentioning the designation first, and in case of transfer or retirement of such a, he shall hand over entire records of the case before demitting his office, who shall continue to be the officer in charge. The successor officer shall immediately report to the head of the legal cell about the such change and due intimation to the nodal officer. In case any adverse orders is passed in a particular case, it shall be personal responsibility of the officer in charge to immediately contact the office of the advocate with certified authentic of the order so as to seek necessary opinion as to act in accordance with opinion forthwith, keeping in mind aspect of limitation. Any lapse on the part of the officer in charge in respect of the case assigned to him shall be treated to be misconduct, dereliction from duties, and appropriate departmental action in the provisions contained under MP Civil Service Conduct Rules, MP Civil Service CCA rules shall be attracted against him. According to the aforesaid, after receiving letter of appointment, the officer in charge shall visit the Office of Advocate General, filing a case, defending a case against the government by filing written reply. Class 26 of the policy 2018 deals with the filing of appeal. Class 26 reproduced below. So that they say. So they say appeal shall not be filed against the ex parte ad interim orders unless stakes are very high or the order is against public interest. Appeal must be filed intra-court in first instance. Direct appeals to the Supreme Court must not be resorted to except in extraordinary cases. Given that tribunals are meant to remove the loads from courts, a challenge order of tribunal should be an exception and not a matter of routine. In service matter, appeal will be generally not to be filed in cases where the matter pertains to an individual grievance which does not cause any major repercussion. The matter pertains to case of pensions or retirement benefit without involving any principal and without setting any precedent financial implication beyond 5 lakh. All these guidelines were given. Kindly go through all this. So, by filing a appeal, by engaging private counsel is barred and several guidelines were given. I request government advocate and other politically interested in law department functioning and the state government functioning must also get information under Right to Information Act whether such rules and such management policies prevailing in Tamil Nadu also or not. Because everywhere and before all courts, I experienced that the courts are tumbling due to the improper behavior and improper dealing of the government advocates, government pleaders, special government pleaders, who are being paid from the out of our exchequer. Best wishes. So this another important thing, the thing is in cases involving government land, properties and administrative control, collector, district authority, the collector will be competent to allow filing appeals, revision in consultation with the government lawyer, where any adverse order, judgment disallowing the claim of is passed by the court. However, if the collector and district authority concerned on the advice of government advocate finds that the appeal revision need not be filed, he shall submit a detailed report duly supported by the opinion of the government advocate to the head of the department, who will consider the matter and take appropriate action. The collector, such district authority, shall keep the head of the department concerned duly informed of the decision taken by with respect to filing appeal, revision, SLP, etc. against any adverse order, judgment concerning the government land property. So therefore, this is most important thing which prevailed in Madhya Pradesh High Court, since after going through the judgment indoor bench, I could not file any earlier citation referred in this case. Therefore, kindly concentrate on this. Best wishes.